Good morning. Happy 4th of July if you celebrate it. If you don't, happy Thursday. I decided to take today off. And, well, hello, Dennis.
See, am I coming through?
You're coming. I'm coming through you.
Okay. Let me, I don't know how to fix that. Darn it. Any suggestions on if you?
Well, I don't do tech support, sir.
I
You know that.
I don't either.
I've never been good at tech support.
Is it good enough to ask a question? Oh, let's see. Maybe I need to turn off. Let's see. There we. Let's try that. Maybe that's good enough. Well, shoot.
I don't know, Statham Speak Out. I don't know. It's part of my natural charm.
Let me write my question out and put it in chat. Sorry, Merv.
Go ahead, Dennis.
I'm going to write my question out, put it in chat.
I know, Dennis. So I didn't make him put his face up. Just so you know, if you do want to come up, though. Oh wait, is that coming through me? Oh, Jesus Christ! I'm the boomer. I'm the boomer. I am so sorry, Dennis. I am so sorry. I was the boomer, not you. Mea culpa, mea culpa. I'm dumb and wrong. Happy Traders Day indeed. So apparently, Statham Speakout, in order to answer your question, I did not find someone who was worse than me. So here's you. People can come up if they want. The only rule is you got to put your face on the camera. Now, Dennis gets an exception because I know him, but that's it. Everybody else, if you come up, you're gonna have to put your face on it. But I'm gonna let Dennis do this. So, hello, Dennis. How can I help you?
Hello there, John. I've got a question that's been racking around the back of my head for a couple of years now, and it finally came up to the front. It's about Turner versus Driver. And it, from what I understand, and the reason I'm asking is I don't fully understand, is it got remanded to the lower courts. Is that a correct statement?
Yeah, some of it got remanded to the courts. Yeah, back to the trial court.
What does that mean?
So what that means is there was a question of law and how to interpret the law. So when the trial court made a decision that went against Turner appealed that decision, and the Court of Appeals made a determination of law. It's not their job to make decisions on who wins, who loses, or whatever normally. They did affirm the trial court's decision on various aspects of it, but on, I believe it was the Fourth Amendment violation for the unreasonable arrest by putting Turner in the car for an hour with no air conditioning, etc. That they said the trial court erred on, that there was no qualified immunity, and so they sent the case back to the trial court to continue, for the trial court to make a new determination based on what the upper court said on how to analyze the facts, and then the case could continue in the lower court.
But did it continue in the lower court?
No, it did not. It did not continue based on Turner's decision not to continue it.
So if it didn't continue in the lower court, and this is still part. I'm not a first year family attorney, and I'd like to promote you to at least a second year family attorney. By the way,
Oh,
uh,
I'm not worthy of that, I assure you.
I believe you are. So if it didn't get finished by the lower court, does that still make Turner versus Driver uh, worth anything?
Yes, the Court of Appeals decision was completed. That is a completed decision that has been published. Even if it wasn't published, it would still be something that you could cite to. But the Court of Appeals decision is done. The lower court trial is not going anywhere. I think they settled, or he just dismissed it without prejudice or whatever. But the Court of Appeals decision has a beginning, a middle, and a completion. It's done. So the Court of Appeals decision is binding. There is a opinion that has been written on it that is forever valid and forever good until a higher court says otherwise.
Okay. Well, that part didn't make sense. Now it does. Well,
I'm glad it does.
and it may have helped other folks too. I don't know, but that's what I wanted to ask this morning. I thank you very much.
All right. You have a great 4th of July.
Take care.
You too. All right. So what we're going to go over today, this is People versus Wigington. So we've covered Wigington just a little bit. We've gone over his various attempts at the federal district court level to have the case removed from state court to federal court, and he didn't get anywhere on that. So he eventually, it went to trial. He lost at trial, and then he appealed the conviction. So that's what we're going to go over today. And what I want you to pay attention to is the analysis that the court uses. Whose analysis does it resemble? Does it resemble my analysis? Does the court talk about the same kind of things that I talk about? Or does the court talk about the same kind of things that Ehline talks about? And let's see how it goes. So we're going to skip over some stuff. All right, background. Following an incident at United States Post Office in Belvedere. I'm going to move this over to this screen so I can see this screen. And I want to do... Oh my God, I can turn off reactions. Oh, hell yeah, brother. You guys can't send those dumb little hearts. And I could also do, how do I do? I want to do live chat. Boom. Live chat. Everybody go to live chat so you can see all the things that, or some of the things that YouTube doesn't want you to see. All right. Following an incident at the United States Post Office in Belvedere, Illinois, the state, that means the state of Illinois, charged defendant. No, the reactions. I know you guys think you're doing what you're doing, but there was like a little like a heart thing that people would click on, and it would make little hearts kind of float up the chat. It was gay. So the state here is the state of Illinois. The state of Illinois charged defendant in an 8-count information with 3 counts of resisting a police officer, 2 counts of criminal trespass to property, and 3 counts of disorderly conduct. 2 of the counts for resisting arrest relied on defendant pulling away from officers after they informed him he was under arrest, and the 3rd premised on the allegation the defendant tensed his arms into a straight position when told by the police to place his hands behind his back. 1 count of criminal trespass alleged that defendant failed to leave the post office building after one employee asked him to do so, and another alleged defendant refused to leave the post office grounds after being directed to do so by officers. 2 of the disorderly conduct charges alleged defendant acted in a manner that served to alarm and provoke a breach of peace based on his communications with postal employee Stephanie Johnson. Well, the 3rd charge for disorderly conduct alleged his conduct provoked a breach of the peace by alarming and disturbing the postal workers present and disrupting their interactions with customers. Now, one thing I want to remind everybody, that the charges in Illinois that the state of Illinois can bring are most likely going to be different than the charges that another state like Texas or California or New York or Alabama or whoever, they're most likely going to be different because each state has its own charges. Now, there are the post office CFR regulations, those are going to remain constant. So if the federal government brings charges, those are most likely going to remain constant. But if you get arrested by state police officers, city police officers, county sheriff, state police officers, but when I say state police officers, just for the record, I mean state, county, and local police officers and sheriffs, etc. Peace officers that are made peace officers by the state. If you get arrested by those guys, you're going to get state charges, not federal charges, but state charges. And those state charges are going to vary from state to state. So don't read too much into what the state of Illinois charged him with, unless you're in Illinois. If you're in Illinois, you could face the same charges. And Go Behind the Line says, or perish. Yes, if you were in gay-ass Louisiana, yes, they have parishes. Everybody wants to be special. Everybody wants to be a unique snowflake. I could have a parish. Perish the thought of ever having you. Pre-trial. Although defendant faced only misdemeanor charges, the matter was litigated in the trial court for nearly 2 years. The main reason behind this exertion of resources was defendant's repeated assertion that the trial court lacked jurisdiction because the offenses occurred on federal property. The court spent approximately a year and a half, this would be the lower court, the trial court, spent approximately a year and a half resolving this issue by ruling on numerous pretrial motions. This included a motion to dismiss, a motion for clarification of the ruling on the motion to dismiss, 2 motions to reconsider the denial of the motion to dismiss, and various other hearings, including a hearing to quash the subpoenas issued by defendant for witnesses to appear at the hearings on the motions to reconsider. Defendant's initial motion to dismiss was a 20-count pleading, and the crux of his argument was that, pursuant to Code of Federal Regulations, 39 CFR 232.1, subsection P, there was no concurrent jurisdiction for the state of Illinois to prosecute him. The trial court disagreed, citing a different subsection of the code and additional case law analyzing jurisdiction on federal land and buildings. It's crazy how in my conversations via these videos with Ehline, he is always taking the strange reading of the CFR, and I'm always talking about case law analyzing jurisdiction on federal land and buildings. Isn't that weird? Okay, Nate. If you're talking about Go Behind the Lines and his silly Louisiana law, they use Napoleonic Code as the basis of their law, not common law. English common law is not a thing in Louisiana because Louisiana was originally French, and the basis of their legal system is the Napoleonic Code, or at least that's what I remember from law school. Now, I don't really think it matters much unless you're in Louisiana. If you're in Louisiana, then it matters a lot. But talk to a local attorney, obviously. Never come to a YouTube attorney for legal advice. Because as DSP once famously said, or at least famously to me, he's not a practicing lawyer. He's a YouTube lawyer. He doesn't practice the law. He sits on his ass on YouTube and talks about the law. Regarding the quash subpoenas, the Office of Counsel for the United States Postal Inspection Service responded to defendant's submission of 2 subpoenas and a request for documents from 2 postal employees. The letter was addressed to defendant and explained that individual subpoenaed would not be compliant due to the fact the Postal Service was not a party to the criminal case, and the defendant failed to comply with the requirements set forth in the Code of Federal Regulations. The letter indicated at the bottom the copies were sent to the trial court and the prosecutor, and nothing in the record indicates this inference is incorrect. It's really hard to enforce state subpoenas on the feds unless you actually comply with the rules set forth by the feds on how to subpoena federal employees, because believe this or not, the Supremacy Clause also applies to subpoenas. The federal government is not subject to the subpoena power of the state unless the federal government allows itself to be subject to the subpoena power of the state. Defendant also attempted to remove the matter to federal court more than once, and those attempts were rejected by the district court. In denying removal and remanding the matter back to the state court, the district court also found the state court had jurisdiction to preside over defendant's prosecution. Defendant additionally filed a writ of prohibition with the Illinois Supreme Court and an interlocutory appeal that was dismissed for failure to follow Illinois Supreme Court rules. He went all the way up to the state Supreme Court. Crazy. Defendant proceeded pro se for the majority of the pretrial proceedings. During a December 2022 court hearing, the trial court turned to the matter of pending motions in limine. A motion in limine is a motion that you file before trial to govern the conduct at trial. You don't chase those chickens, sir. Don't chase those chickens. The classic motion in limine is to exclude certain evidence as being more prejudicial than probative, etc. You want so, for example, in Earl's case, his initial rape trial, where he was placed on trial, he was charged with raping one woman. And what the state had intended on doing was introducing evidence from other women who alleged that Earl had raped them. And they were going to introduce this evidence at a subsequent stage of the trial to try to enhance the conviction. And the Earl's counsel, being smarter than the prosecutor, filed a motion in limine to exclude this evidence of any other rapes that had not been that Earl had not been charged with. And that motion in limine was granted by the court. And so the prosecutor could not bring in any of this evidence of any other rapes that weren't being adjudicated or that hadn't already been adjudicated. And if the prosecutor did, that would be grounds for a mistrial and presumably sanctions, penalties, fines, punishment, whatever against the prosecutor. So the prosecutor's not going to do it. And the reason why you do a motion in limine, generally speaking, is because if you wait until the evidence has been presented to object to it, then the jury's seen it. The jury has already been tainted by it. And so you're not gonna ever get you can't unsee what you've seen. So the purpose behind it is to make sure that the jury or the finder of fact doesn't get tainted by evidence that you can show at the beginning isn't going to be more probative than it is prejudicial, that's going to be relevant, that's going to not have some other evidentiary objection to it. So that's what a motion in limine is. And if you already knew what a motion in limine was, great for you, but some people don't. So I am speaking right now to the lowest common denominator to make sure everybody's on the same page. Defendant immediately claimed that the court could not proceed in the case because of a pending appeal to the Seventh Circuit Court of Appeals from the denial of his attempt to remove the matter to federal court. Additionally, he had once again attempted to remove the case to district court. So he attempted to remove the case to district court. That was denied. The case was remanded back to the state court. He appealed that, and at the same time, he also filed to have the case remanded to federal court again. This is chili level gamesmanship that he's doing. Additionally, he had once again attempted to remove the case to district court. The trial court noted that there had not been a stay of the proceedings. A stay means that they can't proceed. They have to wait till something else gets resolved. And unless instructed otherwise, it would move forward with the case. Defendant then asked for a continuance to obtain counsel. The court denied the request, noting the defendant had waited approximately a year and a half before attempting to hire counsel and repeatedly confirmed his desire to proceed pro se. The court further noted that the defendant remained free to obtain counsel prior to trial. The trial date had been set for 4 months, and the motions in limine had been on file for a month. Moreover, the court believed that the continuance request was a delay tactic. The court then ruled on the various motions in limine over the defendant's objections, observing that the rulings could be revisited at a later time. So what they're essentially alleging here is that Wigington lost on his motions in limine. At a subsequent hearing, retained counsel appeared for a defendant and requested that the trial date be stricken and rescheduled to a later date due to scheduling conflicts in other cases he was to appear in. The trial court indicated that it understood the predicament the counsel was in, having entered the case 2 weeks before trial. But due to the fact that the case had been pending for 2 years and was relatively straightforward, the court was not inclined to move the trial date. The court set a status date and kept the trial date. I'm not going to join you in that ham sandwich. I am going to hope that if News Now Houston, aka Earl David Warden, is innocent and gets a new trial and gets found to be not guilty at the new trial, I hope he gets out of prison. I hope that there is some semblance of justice. I don't ever want to hope one way or the other. I only want to hope for a semblance of justice. And if you want to give up justice just because you don't like someone or whatever, then, well, we are fundamentally opposed to each other's belief systems. Some people think I argue just because I want to argue, and that's completely not the case. If I am making an argument, I am making that argument because I believe that argument is correct, or because my argument is poking a hole in the argument of the other person. Right, but you don't know. I mean, see the problem is, like, what if let's just hypothetical ham sandwich. Let's hypothetical that the victim comes forward tomorrow and says, you know what? I have a confession to make. I made up everything. I was upset with Earl because he wouldn't let me date an older man. And so I made up a story at the time that got me out of the house. And I kept telling myself that story throughout the years because I was just upset and frustrated with Earl, with my dad. And that story grew and changed into something that was completely not reflective of reality. And I've had counseling and therapy now. And I realize what I did. I realized that I lied to myself so long and so many times that I began to believe a lie. And so I want to apologize to the court and to Earl. And I recant my prior testimony. What if that happened, ham sandwich? Would you still hope Earl never gets out of prison? Is there no level of proof ever that could be shown to you that would change your mind? Are you that far gone? If you're that far gone, then, I mean, you're just useless as a person. So anyway, back to Wigington. It could happen, Kelly, and I say it could happen because there is evidence that her story has changed. That her story back when they first picked it up was that Earl touched her boobs, and now Earl was having intercourse with her. He was sexually assaulting her almost every night for 2 years. That's a huge change. That's a bit of a doozy. Now, it doesn't mean that either story is wrong. Both could be true. Either one of them individually could be true, or neither of them could be true. And I don't know. I mean, I don't like Earl. I really don't like Earl. I have literally stated that if Earl shows up on my property, I consider him a threat to the health and safety of my family. And I will take every reasonable step to eliminate that threat to my family. And I hope I'm not being too obtuse about what I mean there. I mean, if I do have to take steps, I'm going to take steps until the magazine is empty. So I don't like Earl. I really don't like Earl, but I also want justice to be done. Earl's threatened my family. I really don't like Earl. I really don't like Earl. He has literally threatened my family. But I want justice to be done. God, I don't like Earl. Yeah, he's a creepy motherfucker. Oh. How Teresa had sex with him, I don't know. Why she got so upset after he broke up with her, I don't know. Because he's creepy. And I would think that she should just be happy that she got out of his life one way or the other, whether she instigated or he did. Anywho, at the status hearing, defense counsel stated he had reviewed discovery and related documents. The majority of the documents were pleadings filed by the defendant. After discussing counsel's other obligations, it was determined the trial date could remain set. Bench trial. Where is Ray? Oh, Raimundo with his little signs. I don't know. He's not here. The case was subsequently called for a bench trial. For those of you who don't know, bench trial means that the finder of fact is going to be the judge. The judge is always the person who determines what the law is. In a bench trial, the judge also determines what the facts are. In a jury trial, the jury determines what the facts are. And defense counsel answered, ready to proceed. The theory of the state's case was the defendant pre-planned this incident in an effort to record a, quote, First Amendment audit, end quote, and post the content to the internet. The testimony and evidence presented were as follows. His right to a fair trial, I think, is really, yeah, he does have a right to a fair trial. First of all, you said taint, which always makes me giggle. Yeah. She would go by his house. She would drive by his house. Teresa would drive by Earl's house. She lives somewhere in Louisiana. He lives somewhere around Galveston, Texas. And she would drive down there to drive past his house. Just to drive past his house. She would drive for hours to drive past his house. Do with that what you will. Yes. It was a travel trailer. It wasn't even a particularly nice one, but he did build a fence around it, and he did build the rape shed that he had electricity hooked up to, and a computer in, so, and a green screen in, so he could do his he could make his content in there. He could make his content in there. Sorry, I'm a terrible person. All right, so we're talking about Annette Turk. Annette Turk has worked for the Postal Service for 36 years and was working at the Belvedere Post Office on the day of the incident. Turk waited on defendant's wife, Beverly Wigington, when she dropped off a prepaid box. Turk reminded Beverly, who was not masked, of the mask policy imposed as a result of the COVID-19 pandemic. Turk explained that Beverly said she did not want to leave the premises after she conducted her business, but instead wanted to speak to a supervisor. Greetings from Transylvania. Turk was familiar with Beverly because she had a post office box, P.O. box, at the post office where Turk worked. Beverly had made several prior complaints about having to wear a mask in the post office. Initially, Beverly was accompanied only by her daughter, but the daughter later left and returned with defendant. Defendant entered the post office and started recording with his cell phone. Turk explained there is an island between the entry doors and the counter. Customers form a line on one side of the island where they wait to approach the counter. That never made sense to me. It never made sense to me from the get-go. I've seen this in other post offices. In the post office near where my office is, they have an island, and everybody like formed a queue, like basically, dick to butt, just just stacked up behind there to maintain space in front of the various places where the cashiers were working, where they're like, you have to stay back 6 feet or something like that. Was it 6 feet? It was something like 6 feet, or else you could give the person in front of you COVID and or the cashier, and then, but everybody's still dick to butt like behind this island. So we're all passing it back and forth back here, but we're safe up there. Just none of it made sense. None of it made sense. No, dick to butt, not dick the butt. Sir, keep it in your pants, sir. This is not that kind of establishment, sir. We don't do that naughty butt stuff here. Defendant entered the post office and started recording with his cell phone. Turk explained there's an island between the insurers and the counters. Customers form a line on one side of the island where they wait to approach the counter. The defendant approached the island and began recording the counter and pay station. Turk was behind. She asked the defendant to put the phone down because she was trained not to allow anyone to record near the counter in order to protect customers' private payment information. The defendant was approaching customers inside the post office and telling them that they did not have to wear a mask. Defendant stayed in public areas of the post office and did not physically obstruct anyone's movements. At some point, defendant came closer to the counter and told Turk that the postal employees were, quote, going to get educated, end quote. In the grocery store that I shop at most frequently, they put arrows on all the aisles, like you're supposed to like follow one way. And initially everybody was doing that, and I would like not follow them because I was just too dumb and I had things to do. I didn't want to walk in giant loops around the store, so screw it. And people would stare at me like, it's going the wrong way. Like, they look at me like I'm somehow going to deliver a package of virus to them by approaching them from this opposite direction they were going. But if I pass them from the back, it would be like no worries, right? Because you can't deliver a virus dick to butt. You can only deliver a virus dick to dick. That's really the problem. Turk did not know what defendant meant by that statement. Defendant seemed worked up, and the situation made Turk feel threatened and uncomfortable. Turk described the atmosphere inside the post office as one of agitation. Defendant's conduct disrupted Turk's interactions with customers. Turk told defendant and his wife that they could wait outside and reiterated the policy regarding masking in the post office and the prohibition of recording transactions with other customers. I'm sure right now some people have left the chat because they're like, how dare you imply that the regulations imposed on us by our overlords were unreasonable in any manner or in any way? They save lives. Wearing the mask saved lives. Queuing up behind an island saved lives. One way through the grocery store saved lives. You're so insensitive. Save lives. Oh, yeah, I remember the circles on the floor. I remember that. I remember they shut down every single mom and pop store in the area, but they let like the Walmarts and shit remain open. So everybody had to pack into the Walmarts. And then I remember also Home Depot. They would let like only a certain amount of people go in at any given time. And so there's just this enormous, because everybody was at home. A lot of people weren't able to work during that whole ordeal. So there's just this enormous line of people just gathered in front of Home Depot. Just a giant crowd of people waiting to get in to get stuff so that they could occupy their time doing minor home improvements. And so you'd wait out there for like an hour to get in the store, then you get your stuff. And I mean, there's no lines inside the store. So, hello, bird. You gonna poop on that chair? So once you got your stuff, you get in and out quick. But like, I was like, this is absurd. Like, you're You're making traffic jams for no reason. If crowds are a problem, why are you making a crowd? Sorry. Stephanie Johnson. Stephanie Johnson was a customer service supervisor at the Belvedere Post Office. Turk came to Johnson's office on the day of the incident and stated she needed help with an individual. I'm not going to read all of these because they're all pretty boring. Let's get to the analysis. Video evidence. We've seen the video. We kind of know what's going on. So the trial court's order. The trial court found defendant guilty of counts 1, resisting arrest, count 2, resisting arrest, count 5, trespass to property, and count 8, disorderly conduct. So trespass to property. The trial court found the defendant guilty of trespass to property. So everybody's going to point to that Ninth Circuit decision. Waits, I believe it was called. Waits. Oh, I love it. I love it, Paul. I'm going to use that line some point in time. Don't tell my wife. So everybody who's pointing at Waits, where remember, Waits was where the federal district court said that the federal government could not assimilate the state of Oregon's trespassing statute and the federal government couldn't charge under the assimilated state trespassing law in federal court. If you were pointing at that as to say why the state couldn't charge a state trespassing law in state court, well, you're wrong, because you see right here that the trial court, stop it. Hey, quit digging. Quit digging. I didn't give any medical advice. I said it didn't make sense. Dan, are you seething? Are you coping and seething, Dan? Seethe and cope? That the stupid ass things they said didn't make any sense? Never take medical advice from a government official, Dan. Never take medical advice from an elected official, Dan. Because they're the ones giving medical advice. They're the ones who removed your ability to take medical advice from, I don't know, your doctor and follow your doctor's advice. They made you follow the medical advice given to you by elected officials and bureaucrats, Dan. And it turns out all the advice they gave was wrong, Dan. Turns out all the advice they gave was wrong, Dan. Turns out it was all bullshit, Dan. And now you're upset because you followed some bullshit advice, Dan. Now you know you were taken. You don't want anybody to know that you were taken. You don't want anybody to know that you don't have a spine, Dan. Is that it, Dan? You mad, Dan? Tell me about it, Dan. Why don't you fucking quit the chat, Dan? Go to your safe space, Dan. Blanket statements. What blanket statement did I make, Dan? Which blanket statement did I make? That it didn't make sense to have people pooling up in a giant fucking crowd if giant fucking crowds were a problem, Dan? What blanket statement did I make, Dan? Why don't you come on up, put your face on, come on up and talk to me about it, Dan. Show me wrong, Dan. I mean, you're entitled to that opinion. Yeah. See, that's a reasonable thing to say. Like, you know, I want to believe what I want to believe, and that's fine. That's all right. They were wrong on everything. Yeah, no, they were wrong on everything. Why do you think we're not doing any of it anymore, Dan? Did the coof disappear, Dan? No, it didn't, Dan. They're wrong on pretty much everything, Dan. Yeah. The coof went away on its own, guys. It's not a problem. People are still getting it. We're just not doing any of the precautions. Why not? Because they're all bullshit, Dan. Accept the evidence of your eyes, Dan. Show me where we're still required to wear masks in stores. Show me where we're still required to stay on 6 feet apart. No. Stick your lips to my butthole, dude. I get to have an opinion. That's the beautiful thing about this country is I get to have an opinion. But anyway, that is a good point, Siberian Husky. I did let things get a little bit derailed with Dan. I like saying that word, by the way. Don't take this. Don't take it. What was that? What was that? Ace Ventura: Pet Detective, because it had Dan Marino. At the end, I don't remember the exact line, but after they found out that Finkel was Einhorn and Einhorn was Finkel, Marino asked Ace Ventura if he had any more cum. I don't remember the exact line, but it always made me laugh every time I heard it. It was something along the lines of like don't interfere with my personal life, or don't ask about my personal life, or something like that. It was pretty fucking hilarious at the time. And so I love saying Dan. Anyway, all right. So the court imposed a sentence of 10 days in the county jail with day-for-day credit, plus credit for 1 day served in pretrial detention. Defendant did not file a post-trial motion. This appeal followed. So he didn't file like a motion for a new trial or whatever. This appeal followed. Analysis. I never got any shots. I got sick once with it, like within the last year. Maybe it was a little bit longer. Time seems to blur together. I just remember that like I lost my sense of taste and smell. It was like I had a bad cold flu, and I lost my sense of taste, which was scary. Like once I realized that I couldn't actually taste anything or smell anything, I'm like, I hope I get this back, because some people, like, it took them a long time to get it back. But I got it back, so yay. But yeah, I got it once. My wife has had it multiple times, and she got the shots and the boosters and stuff. I don't know, maybe it's just different physiology. Oh, is it great? Why was the first Ace Ventura so good and the second one so terrible? The first one was just Shakespearean. It was so good, and Dan was good in it, and the actress who played Finkel / Einhorn was good. I mean, everything was good. Is your number still 911? You're fine, dude. You're fine. All right. So on appeal, the defendant raises numerous contentions of error, which we will address. All right, we're getting into the actual the issues, the legal issues that. Oof. Well, I'm glad you recovered. I got better. Well, you're gay, Nasty Nate, and that guy who played Crocodile Dundee with his vest over no shirt. I'm sure that he tickled your fancy. One of the defendant's main contentions on appeal concerns whether the court below either had subject matter or personal jurisdiction. The crux of his argument is that the post office, where the incident at issue took place, was under the exclusive jurisdiction of the federal government, and that the case, therefore, was not properly prosecuted in state court. Intertwined with this argument are the contentions that the trial court failed to follow precedent in coming to its conclusion that venue was improper, and the trial court erred in barring defendant from arguing defects in jurisdiction at trial. We find that these arguments are all resolved by a review of subject matter jurisdiction, which we review de novo. To the extent we engage in statutory construction, our review remains de novo. De novo means that they don't have to take into account anything the trial court below found. They make their decision on what the law is based on whatever they want to make the decision of the law is. They don't have to give any deference at all to the trial court's decision below. Like for a lot of findings, like where you apply the facts to the law, they have to give the trial court below a lot of discretion. But they could only like say, oh, the trial court was wrong if there was like an abuse of discretion or something along those lines, right? When they're looking at what a statute is and what it means and what it says, they don't have to give any deference at all to the lower court. The authority of the federal government to acquire land is set forth in the United States Constitution and is well established. U.S. Constitution, Article 1, Section 8, Clause 17, Paul versus United States, 371 U.S. 245 at 264, 1963. However, the fact that land is owned by the federal government within a state does not equate to exclusive federal jurisdiction over that land. That's where Ehline fucks up. That right there is where Ehline fucks up. Once he starts off with the contention that just because the federal government owns the land, therefore exclusive jurisdiction, once he gets there, he's done. Like you can't give an analysis that makes any sense if you start off with the wrong proposition. Relevant to the jurisdictional question in this appeal, since 1940, it has been, quote, conclusively presumed, end quote, that the federal government has not accepted jurisdiction over any land it has purchased, absence and notice of acceptance filed by the pertinent department head with the governor of the state or as otherwise set forth by law. And that's 40 U.S.C. Section 3112. The land on which the Belvedere Post Office resides was purchased by the federal government in 1996, implicating the conclusive presumption against exclusive federal jurisdiction. What doesn't make sense, Mystery? It doesn't make sense that just because the federal government owns it doesn't mean that they have exclusive jurisdiction over it or any jurisdiction over it. If you have the question, I'm assuming other people have the question. So tell me what doesn't make sense, and I'll try to answer it. Meanwhile, that they don't have jurisdiction. Okay. At one point in time, they did. At one point in time, before 1940, when they would acquire land, they would so John, you might want to consider that Darby subscribed to me and would put out his opinions after I would put out mine, and his opinions would mirror mine. So if I'm not competent and he's putting out positions that mirror mine, you might want to take a second to let that fucking sink through. Because if his opinions mirror mine and I'm not competent, that means he's not competent, you idiot. How fucking dumb are these people? My God. All right. So before 1940, if the federal government acquired land, then the federal government had exclusive jurisdiction over that land unless there was some other agreement with the state, right? But think about this. Does the federal government want to expend the time and resources to have jurisdiction over all of these little pieces of property? The post office, a federal entity, decides that it needs a new post office in this little town. Does the federal government want to have to pay to have a police force for that little tiny ass post office? Or would they rather say, you know what, we'll just let the sheriff deal with it? The state has perfectly good laws that are going to handle every kind of problem that can arise in essentially a commercial business. The post office is a commercial business. It's just like a UPS store or something like that. So why don't we just let the sheriff do it? Why don't we just let the sheriff take over it? It saves us money. It's not really an extra cost. I mean, it is an extra cost to the county, but it's a fairly low cost. So Ehline's a real lawyer. Well, yeah, he is a real lawyer. Darby's a real lawyer, but I'm also a real lawyer. I'm also a real lawyer. Like I have all three of us, me, Darby, and Ehline, are all licensed to practice in California. Like you don't even know what the words you're using mean. I am a real lawyer. Oh well. Anyway, you can't. All right. So Mystery says she understands it now. All right, perfect. So in 1940s when they decided that they didn't necessarily want to have to take jurisdiction over property, and so basically the federal government said, if we want it, we'll take it. If we don't want it, we won't take it. Why would I humiliate you, Hefe? I like you. I mean, I will humiliate you if you need it. No, he literally said Darby and Ehline, because they, meaning Darby and Ehline, they is the previous people, they are more competent than you. So he is literally of the position that Ehline is more competent than me. I think he is. You got to remember, Paul, that this guy is the one who's arguing it. So you got to like give him, you got to like help him out. You can't expect him to be 100% right, but you can figure out what he's trying to say and you can address what he's trying to say. So there you go. All right. So in response, the defendant did not provide any documentation that comported with the requirements of Section 3112 of the United States Code, nor did he point to any other method by which the federal government obtained exclusive jurisdiction. So the requirement was on the defendant, Wigington, to show that the federal government had exclusive jurisdiction. And that's what we saw when I pulled up the last time I pulled up lists of various FOIA requests for documents showing, that the somebody had asked for, demanded exclusive or concurrent jurisdiction. There was a list from the GSA list FOIA jurisdiction. I can't find it now. I found it before. How do I open this up in? Present. I don't know how I present this. It's a spreadsheet. Oh no, I've done videos in full suit jackets. I've done videos. Look, some of my older stuff, I'd go out like I'd make videos like outside of courthouses while I'm waiting to go in or whatever. No, you're close. Never trust any lawyer who isn't your lawyer. Always trust your lawyer. I don't know. Oh, really? I wonder why. I wonder why they edited it to remove the dates. Anyway, that isn't loading, and that's very irritating. Well, anyway, moving on. This isn't the hell. My computer really doesn't like trying to open up. Maybe that's a maybe that maybe that sheet from gsa.gov is corrupt. Bum us, dude. All right. So anyway, moving on. He said load. What if my lawyer is Nick Rekieta and Robert Barnes? Well, Nick Rekieta isn't taking cases, and Robert Barnes, you probably won't get him representing you. Yeah. Oh, that. Mm-hmm. That wouldn't show. That wouldn't show whether or not they'd requested exclusive or concurrent jurisdiction over it. I don't think Robert Barnes, by the way, would deign to represent anybody who wouldn't personally represent anybody who wasn't famous. I work with a lawyer who has been practicing law for a long time, and he represented a Hell's Angel, like the head of the Hell's Angels back in the 80s, in an appeal. At the trial level, this Hell's Angels guy, he was the head of the San Francisco chapter of Hell's Angels or whatever. He hired Melvin Belli, who is a famous attorney. If you don't, you've probably heard the name Melvin Belli. He hired Melvin Belli to represent him at trial, and Melvin Belli showed up at the very first, like at the arraignment, and then never showed up again. He had an associate who did all of the rest, and so this Hell's Angels guy was kind of upset, was irritated. He lost, by the way. That's why there was the appeal. He was irritated that he paid Melvin Belli money to get not Melvin Belli. So I don't know who Josh Moon is. Yeah. All right. Anyway, back to the case at hand. So instead, he points to the section of U.S. Code that provides any lands reserved or acquired for the use of the United States and under the exclusive or concurrent jurisdiction thereof, or any place purchased or otherwise acquired by the United States by consent of the legislature, in which the same shall be for the erection of fort, magazine, arsenal, dockyard, or other needful building. However, as has been pointed out in both the trial court and the district court, nothing in this provision mandates exclusive federal jurisdiction over properties such as the Belvedere Post Office. Defendant also argues that Section 410, 39 U.S.C. Section 410, which describes the applicability of other laws to the, quote, powers of the Postal Service, results in the inescapable conclusion that the, quote, conclusive presumption, unquote, against exclusive federal jurisdiction does not apply. We remain unpersuaded. Whatever that reference is, it escapes me. Yes, that was the quote from Ace Ventura. It always made me laugh my ass off. So we remain unpersuaded. Our review of Section 410 reveals a legislative decision to exclude the actions of the Postal Service in conducting its operations from the scope of judicial review and scrutiny under the Administrative Procedure Act, 5 U.S.C. Section 553, among others. Essentially, Congress was granting the Postal Service a waiver in this provision from federal laws it found could be overly onerous to its operations. A reading of the section does not reveal an intent to exclude the Postal Service's property procurement from the framework for jurisdiction set forth in Section 3112, 40 U.S.C. Section 3112. Section 410 serves to set forth the powers of the Postal Service, not the jurisdiction of the federal government. Accordingly, Section 410 does not impact the conclusive presumption against exclusive jurisdiction of the federal government. Laces out, Dan. Wait a minute. I think I'm understanding. So you're telling me that Barnes shared information, confidential information he learned from a prior client in order to defend someone who is not a client in the first place. But regardless, he used information that he learned in confidence from a prior client and made it public. He didn't share the info. He just said something potentially damaging. So if he doesn't share some, that's borderline. That's real borderline. Like that, the attorney-client confidentiality is basically one of the most precious protections that Jesus fucking Christ. Apparently this is clucking hour. It's not inviolate, but it's almost inviolate. It's pretty bad to even hint at stuff like that. It's pretty bad even just to hint at it. I don't know. All right, so defendant also points to section 232.1p1 of the Federal Code of Regulations, which controls conduct on postal property. Subsection P, titled Penalties and Other Law, provides, and I just want to remind you that Ehline uses this same section in the same way and has completely avoided my interpretation of it. Penalties law, which provides, 1, alleged violations of these rules and regulations are heard, and the penalties prescribed herein are imposed. It's so loud here. These are hens clucking, by the way, not cocks. This is like their egg calls. They're looking for places to lay. Oh yeah, you would definitely every single state bar that Barnes is a member of can and should investigate that. Can and should. Well, we'll start all over again for Cheeky Monkey. So we're gonna go back to the beginning. We were halfway through it, but we're gonna go back to the beginning for Cheeky Monkey. This is people of the state of Illinois versus Richard Wigington. So everybody else has heard this before, but for Cheeky Monkey, Wigington was the guy that we've seen a video of previously get arrested by state police. He got arrested by state police in a post office for, among other things, trespassing. You know, if I only had 0.3 acres, I can imagine it would be a lot harder to have a bunch of chickens. Especially since chickens can fly for short distances, especially if you put up a very short fence that they could fly over, they could get to places where dogs can get to them. And so if you have neighborhood dogs that could get to them because you don't have a fenced-in property and fence is sufficient to keep your chickens in, well, then that's just a recipe for failure. I don't fault Todd for homesteading, but I do fault Todd for being incompetent at it. So I support him in his homesteading, except he really should take the effort to make sure to close up the chickens and protect them from errant dogs. What, you don't want to go over everything again, Paul? You don't want to start over from the beginning? We have to do this for Cheeky Monkey. All right, so Paul overruled me. We're going to go back to about where we were. Accordingly, section yada yada yada. All right, so number one, alleged violations of these rules and regulations are heard, and the penalties prescribed herein are imposed either in a federal district court or by a federal magistrate in accordance with applicable court rules. Questions regarding such rules should be directed to the regional counsel for the region involved. So when they say alleged violations of these rules and regulations, they're talking about the violations of 39 CFR 232.1. They're not talking about alleged violations of state laws. Number two, whoever shall be found guilty of violating the rules of regulations in this section, again, these are the Federal Code of Regulations, not state laws, while on property and charged under the control of the Postal Service is subject to a fine as provided in 18 U.S.C. Section 3571, or imprisonment of not more than 30 days or both. Nothing contained in these rules and regulations shall be construed to abrogate any other federal laws or regulations or any state and local laws and regulations applicable to any area in which the property is situated. Defendant focuses on the first section to the exclusion of the second, which is exactly what Ehline does. When considering the plain language of the regulation, subsection 2 plainly contemplates, or what they were trying to say was it clearly contemplates concurrent jurisdiction for offenses occurring within a post office where exclusive jurisdiction has not been reserved. Such interpretation becomes even more cogent when placed in the context of the United States Code relating to federal jurisdiction, see 40 U.S.C. Section 3112. Within the same section, defendant also directs our attention to subsection Q, titled Enforcement, which provides, number one, members of the U.S. Postal Service security force shall exercise the powers provided by 18 U.S.C. 3061 C2 and shall be responsible for enforcing the regulations in this section in a manner that will protect Postal Service property and persons thereon. Again, they're being charged with enforcing the regulations, not state laws, but the 39 CFR 232.1 regulations. 2. Local postmasters and installation heads may, pursuant to 40 U.S.C. 1315 D3, and with the approval of the chief postal inspector or his designee, enter into agreements with state and local enforcement agencies to ensure that these rules and regulations are enforced in a manner that will protect Postal Service property. 39 CFR 232.1, etc. I don't name the hens, and my wife does. She has names for all of them, or at least I think she has names for all of them. Every time I ask, like, oh, I like this particular chicken, it did this, and that. She'll be like, oh, you're talking about Elizabeth Taylor. Sure, it was Elizabeth Taylor. Elizabeth Taylor, by the way, is a lavender. It's a lavender bird. I know which one Elizabeth Taylor is. But she has named none of them Ehline. But she does make mayonnaise out of their eggs from time to time. What I really like is she makes egg salad out of their eggs. So she makes the mayo out of their eggs, and then she makes the chopped up eggs, the hard boiled eggs, out of their eggs. And so it's like it's eggs and egg sauce. It's really good. It's oddly good. Like, you wouldn't think eggs and egg sauce would be that good, but it's really freaking good. I can hear Dick back control right now. Well, why don't you have her make you an egg salad sandwich every day? If you're so into health food. Oh, that guy was fucking hilarious. All right. Unintentional hilarity is the best. Defendant argues that these sections provide that only the security force of the Postal Service could enforce the provisions of the section, and an intergovernmental agreement or memorandum of understanding was required before local law enforcement could enter the post office and enforce state law. Who else? It wasn't a lavender Orpington. I see you, Misty Eyed Girl. It was not a lavender Orpington. It is a lavender bird, but it's not an Orpington. So we have other Orpingtons. We just don't have a lavender Orpington. And this is a lavender bird. It's all lavender. It's like gray, but it kind of looks purpley in the right light. So this right here, this intergovernmental agreement or memorandum of understanding is required before local law enforcement could enter the post office and enforce state law. This is Ehline's argument, and it fails. This argument, says the Illinois Court of Appeals, is without merit. So every court who has looked at the Wigington case, the federal district court, the Seventh Circuit Court of Appeals, the state trial court, the state court of appeals. Apparently, he filed a writ of mandate to the Supreme Court, who rejected it. Not the U.S. Supreme Court, the Illinois Supreme Court. Every court that's looked at this issue has said you're fucking wrong, Wigington. Which, since Wigington's argument is Ehline's argument, it means Ehline's wrong. Since Ehline's argument is BZ Watchdog's argument, BZ Watchdog is wrong. This is how you know your interpretation of the law is wrong, is when every court that looks at it says you're fucking wrong. That means you're wrong. And what's really weird is that Ehline, who is apparently a real attorney, according to this Anderson fella, his argument is exactly the same as a pro se litigant's argument is. Isn't that crazy? Puce. Puce is a pretty gay color name. Similar to defendant's interpretation of subsection P1, defendant's argument on this subsection ignores the express non-abrogation clause in subsection P2. Local law enforcement was enforcing state law, not the provisions of the Code of Federal Regulations, and nothing in subsection Q2 mandates the existence of an intergovernmental agreement or memorandum of understanding to do so. Baby. Our analysis leads us to conclude that the Belvedere Post Office is not a federal enclave, and that exclusive federal jurisdiction does not lie. This eviscerates defendants' arguments relating to personal jurisdiction, the application of the Federal Assimilative Crimes Act, that venue was improper in the Boone County Circuit Court, and that the trial court erred in granting the state's motion in limine, precluding him from arguing jurisdiction at trial. Accordingly, the Circuit Court of Boone County had both subject matter and personal jurisdiction, and venue was proper. I'm not going to go through any of the rest because it doesn't really apply, but you could see that the arguments that Ehline makes that mirror the arguments that Wigington makes are wrong, and they have been rejected at every single level that they've been tried at. This is Boone County, Illinois, not West Virginia. Yay! So no one else has decided to come up. I'm going to assume that nobody has any questions, comments, or suggestions. That is it for today. Thank you for watching. Drink responsibly. Use fireworks responsibly. I'm not going to be using fireworks in my area. There's fires up above me, fires down below me, fires to the west of me. I don't think there's any fires to the east of me, at least not in California. Wasn't Ehline saying that it was overturned? What was overturned? Oh, we got to balance it. Wigington versus Postal Service petition for a writ of certiorari is granted. The judgment is vacated, and the case is remanded to the United States Court of Appeals for the 7th. Ooh, let's look it up. Let's look it up, boys and girls. Let's do this. See if it's in Google Scholar. 22-2020 1286 Wigington. Well, let's do this case law. Select courts, clear all. 7th Circuit Court of Appeals, done. Wigington. Since 2020. Sort by date. All right, so 7th Circuit Court of Appeals. Opinions and orders. Opinions and orders. Well, that's a 2022 case, so we'll do from 01/01/20 to 0. Wow. 2022, January 1. End date. Oops, I'm sorry, we're sharing this episode. Through today. Last name is, no, we don't want the author. Case year is I don't know what that means. Case number is 1286. Submit. Wigington, Richard. Uh, 22-1286. -1286. Where are you getting this from, Jason? I'm not finding this. How about we do this way? I'm going to go into Pacer. No, I want to do court listener.com Wigginton Richard. Wigginton court listener. Here's a Wigginton versus the state of Illinois appeal. There's another. Let's see if we can't do it. Parties and attorneys. Can we do Wigginton? Can we do? Can we search by Wigginton? So there was definitely an appeal, which he lost. See right here, plaintiff appealed and the Court of Appeals summarily dismissed the appeal. So a summary dismissal means that there was no opinion issue. So they summarily dismissed the appeal because the district court properly remanded this case to the state court. That was Wigginton versus state of Illinois. This one, there's not going to be anything on it because it was. That's all you're going to get right there. So he lost the one appeal, but there is no 22-1286. There's literally no 22-1286. Ooh, what if I do it this way? 1286. 22-1286. All right. So Jason Heller, are you still here? You still here? I'm not suggesting that you lied to me, Jason Heller. I am not suggesting that you lied to me. I am suggesting, Jesus Christ, did you just fart, boy? Oh my God. Huh. Bro. That's disgusting. That is, it's in my mouth. I'll be right back. I had to go get some carbon dog treats because God, that was terrible. Okay. So it looks like Jason Heller took a shit and then left, but that's fine. So, share this tab instead. All right, so this is 22-1286 from the Seventh Circuit Court of Appeals. So the Seventh Circuit Court of Appeals did have a case, 22-1286. It was, however, Lee versus Edelman. Lee versus Edelman was the case. So there is no case, 22-1286, that reflects Wigginton at all. So 22-1286, there is no Wigginton Richard versus Postal Service. That doesn't exist, Jason. Like, I'm sorry, that doesn't exist. I don't know if you're the person who came up with it, or if yes, if you're the person who posted it, or if this is something that Ehline gave to you, but the case that you're looking at doesn't exist. The case that you're looking at doesn't exist. This is the actual Wigginton appeal. This is Wigginton versus State of Illinois, number 22. Oh, wait a minute. The post office. This is his lawsuit against a post office. It's still not a good case number, but let's look at select courts. Let's look at select all. Done. Let's look at Wigginton Postal Service. I always add an extra G to Wigginton. Oh, God. Okay. This is Wigginton versus Postal Service. Oh, Christ, bro. I got a cookie. Oh. That hasn't gone anywhere, though. I'm still. How about we do this? Pacer logging. We want to go to which district court is this? Northern District of Illinois. We're going to go to Illinois Northern District. Log in. Log in. Log in. All right. So we're going to query, and we're going to go to last name, Wigginton, first name, Richard, and we're going to go exact matches only. Run. So hold on a second. Hold on a second. Just don't blame me on this. We feed Diamond Naturals. It's on dogfoodadvisor.com. It's a 5-star food. My other 2 dogs are just fine. Kenzie has always, he was my sister's dog, and she moved to a place where she couldn't have him anymore. So he's now our dog, and he's always had just absolutely terrible gas. And it doesn't matter what, it literally doesn't matter what you feed this dog. There's something in his gut that he just produces terrible gas. And so we load him up on charcoal cookies to try to help out. And they take the edge off, but apparently we haven't been cooking him up in a while. But that's all they do is they take the edge off. Like, it's terrible. He does also get like we'll put like an egg or something in his food every once in a while. We do that for all the dogs. And eggs might do it, but like the other dogs aren't like this anyway. All right. So we've got 4 matching people. We've got Wigginton Richard. We'll do him first. All right. So neither of these are it, so I'm going to ignore that. We're going to go back to this tab. We're going to look at this one. All right, so Homeboy has filed against the post office. He's filed 1, 2, 3. This USPS one was closed. This is the one he filed in 2022. And he has 2 open. So he's doing the whole chili multiple, just litigate the shit out of everything with everybody. So we're going to go to this one now. Wigginton versus Babcock's Pool. It was terminated. I want to do a search on that. So this is also against the USPS. Oh, this was one of his many petitions for removal that he lost. And finally, there's this Wigginton. This is versus Storage USA. This was back in 2001. So this isn't a thing. So these are back from 2011, so I'm going to ignore them as well. This post office one was did I already find a 5044? 5440? 5440? Yeah, so that one was this one. Closed 1/11/23. 1/11/23. Entered judgment. Closed. So it's still closed. So that one's still closed. I think you're right, Lyncher. I think I am on a wild goose chase. So again, so let's go back to what John Anderson said at the beginning about me being jealous of the real attorneys. Real attorneys don't have to make up decisions. Real attorneys can actually rely on the decisions that have been made. There is no decision that I am aware of that I can find stating that the post office in Belvedere, Illinois is somehow a federal enclave. So, and the one that Jason Heller provided does not exist. So I'm sorry, Mr. Heller. I don't know if you're a liar or if you've been lied to, but some way or another, you're wrong, and that sucks. All right, so that will probably be the end of it for today, since no one else is coming up with anything. Thanks for watching, and have a great 4th of July.